High Court in Port Harcourt has ruled that River State Governor Sim Fubara can conduct official business with 3 lawmakers at the State House of Assembly who, in the opinion of the court, have not vacated their seats. Details of the judgment, which was delivered on December 20, 2024, has just become public. The presiding judge, Sika Apiroku, dismissed a lawsuit brought by the registered trustees of the Association of Legislative Drafting and Advocacy Practitioners. The suit sought to compel the governor, Fubara, to resubmit the 2024 budget to the faction of the State Assembly led by Martins Amewule. During the hearing of the matter on November 12, 2024, counsel to the defendants, Lawrence Okojaja, tendered documents to the court citing a precedent where the River State House of Assembly, with only 6 members, transacted business with the then governor, Nyesom Wike, between December 2015 and February 2017, confirming appointments and passing the 2017 appropriation bill into law with a number less than 24 members that ought to form a quorum. In his ruling, the judge agreed with the submissions of the defense counsel. Now let's have some conversation with on the River State High Court's ruling with lawyer and Rise News analyst Frank Tietie. Frank, good evening. Thanks for joining us on Newsnight. Now we've seen the court's ruling granting Governor Fubara the authority to transact business with just 3 lawmakers. Now this raises questions about the practicality of governance, right? Given this precedent, how sustainable is it for a state like Rivers with pressing needs, developmental needs, to function effectively with such a skeletal legislative structure?
Well, I think that we're experiencing very strange times in our country, given the kind of very strange and highly unsubstantiated and unbecoming judgments that proceed out of the Nigerian courts. Whenever a court is approached with an application for a declaration, what the court does is to state the correct position of the law, applying to facts if there must be consequential orders, even though because their declaratory orders are not meant to be that kind of, that receive that kind of enforcement. So it's strange that a judge in a Nigerian court would endorse a position that is directly against the law, the provisions of the Constitution, and the decision of an appeal court, in this case a higher court than the High Court. For a court to be approached, and that also brings to the forefront the level of degradation of the interplay between politics, law, and whether or not it can achieve justice. I think we are constantly witnessing, a dissension, a reduction of the whole pursuit of state power to a point of the ridiculous, where we no longer consider fundamental norms, fundamental provisions.
Okay, Frank.
So in Section 96 of the Constitution, that declares that the quorum of a House of Assembly shall be 1/3 of the total number of members of the House of Assembly. So it becomes very strange, and I restrain myself to say that it is strange for a court to declare that 3 members are sufficient to form a quorum. One would have also expected that, given that the appeal court has declared that the Martin, and I do not make any apology for the Martin Amewole-led factional, House of Assembly, but that is what the court says. It is strange for a court to sound political, as if it is campaigning in an election.
Okay, let's talk about the budget presentation and the passage, right? It's a critical instrument for government.
Of course it is.
Lying in the hands of 3 people, right? 3 members, 3-member assembly. How does this scenario compare to the similar instances that we're talking about in the courts during Governor Wike's tenure? Do you foresee any sort of legal or operational challenges when it comes to implementing that 2024 budget?
I'm a lawyer, and I'm supposed to speak to the state of the law. And the law is what the court say it is, or what's written in the law books. As we speak, the Court of Appeal has said, well, the budget that has been presented to a 4-man member of the House of Assembly, it's invalid, and as such, it should be represented to the Martin Ameole 27-man House of Assembly. So why would a high court, brazenly disregard the judgment, the final judgment of the Court of Appeal? Section 287 of the Constitution mandates every authority in Nigeria, and particularly every court of subordinate jurisdiction, to submit, to enforce the provisions of the judgments of the Court of Appeal. So what we witness with this judgment, simply validates the frustrations many people have with the state of the law and the judiciary in our country today. And unfortunately, there is hardly much the NJC can do. So I go back to your question when you say, what happens to the all-important legal instrument called the budget? As it is, there is, given the judgment, the already existing judgment of the Court of Appeal, the Rivers State does not have a legal document, does not have a budget appropriation law appropriation law in place. It doesn't have. And then one would have expected, and I say this with utmost respect for the courts and for the particular judge, the judge in Rivers State, that he ought to have been guided by the provisions of the Constitution by simply saying, look, the Rivers State, or those who are responsible, the authorities, whether it's INEC or whoever, should make everything possible to ensure that there is a valid House of Assembly in place, and not making reference to some historical precedent that because they are fighting and they are abusing themselves in Rivers State, foisted by the excesses of the Minister of the Federal Capital Territory, to the extent that Rivers State is not embroiled, is not making a mockery of our democracy.
Frank, tell us.
So what would have happened is that they should have simply stated that this is the proper thing to do. What is this? Utter confusion and degradation, and deriding our constitution that we are witnessing in Rivers State.
In your own view, quickly before I let you go, what then should happen? Since this court did not adhere to what the appeal court has already said, does this judgment leave the door open for sort of the Supreme Court to
I think that the National Judicial Council should be incensed, should be enraged at this point. It is becoming helpless, because this is politics. This is politicians overriding the judiciary, now making nonsense of the judiciary, now telling us straight in the face that we can use the judiciary as an instrument, turn it in whichever way we want. Look, if the punishment these judges for their malfeasance and turning the law upside down is simply insufficient. What you simply just reprimand the judge or retire him when he barefacedly destroys the legal foundation of this country and then puts democracy under threat? No, because the reward he possibly gets for making a political judgment can far outweigh whatever it's going to get as a retired judge. So this thing is utterly annoying. Follow the law, and I do not make an apology for all of those persons who are causing confusion in Rivers State, particularly the Minister of the Federal Capital Territory. All of these things ought not to be.
All right, Frank, thank you so much for joining us. Frank Tietie, who's a lawyer and a Rise News analyst.